Welcome back to U.S.S.G channel. My name is Anton Yeltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. Last week we started a new series of videos dealing with career offender status under federal law and under the guidelines. And specifically, we tried to define controlled substance offenses under federal law. This week we continue on that mission and we're going to try to define controlled substance offenses and focus on marijuana law. In many cases, marijuana statutes under state convictions, under state law, are no longer fit within the definition of a controlled substance offense and should not be used in the calculation of your guidelines. This week, we're focusing on United States versus Batista, a Ninth Circuit case from 2020, which redefined how we interpret state marijuana cases under federal law. So let's go ahead and focus on the case. Per usual, I'm going to give you some facts, and then we're going to talk about the law. So, Mr. Batista was charged with possession of ammunition by a convicted felon under 18 U.S.C. 922 G1 and 924 A2. So felon in possession charge. When we look at the guidelines, we have to look at the gun guidelines, which are found in 2K 2.1. I'm going to put the guidelines in the description under this video so you can look at all of the guidelines, but focus on the 2K 2.1. Being a felon in possession of ammunition, having the prior felony record, he would find himself at a base offense level 14. When I say base offense level, this is the starting point when we calculate the guidelines. Of course, he might get more reductions, such as accepting responsibility by pleading guilty, or there could be other reductions or enhancements under the guidelines. In this situation, Mr. Batista gets an enhancement written into his pre-sentence report by the probation to level 20 under 2K 2.1 A4A. Why? Because under this section, it tells the court that if somebody is a felon in possession, has a prior felony conviction that prohibits him from possessing firearms, and has an additional controlled substance offense or a crime of violence offense, then he would jump from base offense level 14 to level 20. In this situation, we're not focusing on a crime of violence, we're only focusing on a controlled substance offense. Now, Mr. Batista timely objects and says that his state convictions, his prior, is not a good predicate under the guidelines as a controlled substance offense. He was convicted in Arizona of an attempted unlawful transportation of marijuana for sale under section 133405 A4. He says that because marijuana has been redefined under federal law, it should not be used in the calculation because it is no longer a controlled substance offense. So, something that we have to understand in federal law. Perhaps some of my clients have federal convictions, which makes it somewhat easier to figure out if that conviction is a controlled substance offense or not. But most of my clients have prior state convictions. In that situation, your attorney should try to interpret whether that state conviction fits within federal law. So we're interpreting state law under the federal definition. And the timing is important. When we're comparing the elements, we have to compare the elements of the state crime as they existed at the time of the conviction. In this situation, the Arizona conviction was from years ago. But we have to compare it to the crime as it's defined under federal law during sentencing. So we have to look at the marijuana definition at the time of your sentencing and compare it to the definition of marijuana as it was defined back when you were convicted in that state conviction. So I hope you understand what I mean in terms of timing. In this situation, on December 20th, 2018, the President signed Agriculture Improvement Act, which removed hemp from a schedule of controlled substances. So it redefined what marijuana means. And under federal law, if you're convicted of transportation, importation, or any other crimes related to marijuana, hemp is no longer included in that definition. Now, Arizona statute contained no textual exclusion for hemp back when Mr. Batista was convicted. And it made no distinction for cannabis of low THC concentration. So because it is not a categorical match, the state statute is overbroad. It encompasses more of marijuana definition than federal law at this point. Because of that, Mr. Batista is correct. The Ninth Circuit agrees that marijuana under Arizona law does not fit within a controlled substance offense definition. And so it cannot be used against him in calculating the guidelines. To quote the Ninth Circuit, it is illogical to conclude that federal sentencing law attaches culpability and dangerousness to an act that at the time of sentencing, Congress has concluded is no longer culpable or dangerous. Which makes sense. If hemp is no longer dangerous under federal law, how can we still use that conviction from back in the day when the state conviction, state law, still included it? It doesn't make any sense. And in fact, the Ninth Circuit goes further to tell us that if we continue to use old definitions, well then how does the Congress supposed to change the law? It doesn't make any sense. To conclude this video, I want to say a number of points. One, you now understand that marijuana under many state convictions is no longer defined in the same way as the federal law defines it. So in this situation, he will not go to the enhancement of 20, he will stay at level 14. Another issue we have to focus on is where are we in the guidelines? This definition of controlled substances appears in the gun guidelines under 2K 2.1, but it also appears in the career offender guidelines. So if you're an individual that has a number of crimes of violence or controlled substance offenses in your past, well, some of those controlled substance offenses no longer count towards a controlled substance offense definition. And then, of course, let's remember, I'm in the Ninth Circuit, so you have to look at your own circuit law. But Arizona and California are in the same circuit, right? And so in this situation, I had a client who had a California prior for transportation of marijuana. And in that case, just like this one, I relied on this case, the Batista's Ninth Circuit case, to say that California also redefined marijuana only recently. And my client was convicted back in 2009. And in 2009, the definition of marijuana under California law also included hemp. And it no longer is included under federal law. So it should not be counted in my client's case as well. So look back at your criminal history and see whether you have any marijuana related offenses and if they actually fit under the controlled substance offense under federal law. I hope this video has been helpful to you. If you enjoyed it, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.